Alex here with part 140 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my access parental rights have been terminated. Number two, the nutshell version as to the purpose of this series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We now move into the other case, the writ petition case. I've already won this. I've got a writ of mandamus to issue, but now and in fact, I did file a motion for costs, and now we are going into the court's order denying motion for costs. This is my first appellate victory. He denies this motion, I file an appeal, and I win. And it is a sweet victory because I do remember him citing in his upcoming election that he had never been overturned on appeal. So it looks like it's either me or me and some other person that hit right at the same time, like within a week of each other, just boom, boom, two reversals. In any event, it was definitely satisfying considering how many times he had violated the law in this case, and even more so satisfying that it was in this case, the writ petition case, because if you remember correctly, in the other case, the child custody case, he denies my fee waiver. And that is how he defeats my appeal in that other case where he imputed my income for willful underemployment for going to college. And in this case, he can't do that because I've already got forma pauperis status because of an order entered by the chief judge way in the beginning of the case before this judge was even on the case. So I'm able to sort of circumvent his strategy, which is to outmoney me, to basically exploit the fact that I'm just a poor college kid with no money to defeat my appeals. He can't do that in this case because Chief Judge David Hardy has already given me forma pauperis status in this case. So I take advantage of Chief Judge Hardy's order to get around him, to get to the Supreme Court for free, and they do overturn his order denying. So it is an exciting moment in the My Docket series because it is the first of 4 appellate victories. And I think with all of this having been said, we can just go ahead now and take a look at what this judge has filed. Here we have the court's order denying request for costs. By the way, it was not a request for costs, it was a motion. I didn't request kindly for an award of costs. I filed a motion with points and authorities. This is the order that I have referenced in the past where the judge sort of twists himself into a logical pretzel to find a reason to deny the motion. This is the first time you'll see me win an appeal on this basis. All of the other appeals that I win, I think the judge didn't even probably read their order. They probably had like a paralegal or a clerk or whatever prepare their order and they just signed it without reading it. That's my suspicion for the other judges. This judge is the only judge that I think put a whole lot of effort. I think he personally worked on this order, and I think that he still got overturned, which is nice. But I do want you guys to notice that this kind of effort going into an order denying, I'm not sure is that usual. You're going to see me win appeals number 2, 3, and 4. And those orders, which are a little bit more blasé, is typically more of what you're going to see. So again, I just want you guys to kind of have your head in the right place. You're not always going to see a judge put this much effort into denying your motion. Typically, these decisions get overturned because the judge just didn't put enough effort or thought into it and they just missed something just because they were rushing or didn't care. This is the opposite sort of situation where the judge seems to have cared a whole lot about it, put a tremendous amount of effort into it, and it still got overturned. So again, this is more of the anomaly and it's more of the exception, not the rule. Anyway, first paragraph, we have standard introductory paragraph that he has reviewed my motion for costs, the memorandum of costs. No response or opposition has been filed. This is a huge deal. I have talked about this in the past, I think in videos like filing an appeal and such. When no opposition is filed and the judge denies an unopposed motion, it is very risky for the judge to do this, because if you file an appeal to that unopposed motion, now your opponent, the respondent, they have waived all arguments. They can't even participate in the defense of the appeal. which puts a judge like this in a very vulnerable position of being overturned on appeal, because you're going to present to the Supreme Court a one-sided argument. And you're going to see that when I file the appeal to this case, you're going to see that the Supreme Court orders that my ex is not allowed to participate in the appeal unless they say otherwise, and she actually never gets the right to participate. They just read my stuff and they just ding the judge on appeal. So, I mean, if you see a situation like this where you file a motion that's not opposed and the judge denies it, just take advantage of the fact that you're going to have a whole lot of wind in your sails on appeal, because your opponent doesn't have anything that they can cite to. They never opposed it. So take advantage of that. If you have a judge like this who thinks that they're going to defend the other side for them on their behalf, just go ahead and fight it, So I'm going to talk more about that when we actually get into the appeal, when you start to see actually the orders that are entered by the Supreme Court in this case. But for now, let's go ahead and proceed. The court finds and orders as followed. Number 1, in my motion, I assert that the court should not assess costs against the named respondent, the Secretary of State, since its role was, quote, merely observational, unquote. I state that I state that the government committed no wrongdoing in issuing the fictitious address. I allege that the respondent was candid in all its filings and actually helped facilitate the speedy resolution of this case, which is true. The government, or more specifically Kevin Benson, the attorney who took part in this case, did a wonderful job. He was candid, he was honest, he was truthful, and he helped facilitate speedy resolution. He didn't do anything to slow me down. He didn't get in the way. He didn't play any games. He was very professional in everything that he did. And I don't think that the Secretary of State deserves to be punished for doing that. They complied with the law and they participated in the proceedings very honorably and honestly. Let's go ahead and move on to the next section. I'm asking the court to assess costs against my ex. I have pledged, quote unquote, I don't know why he thinks this is like some kind of, I don't know why he does it. I feel like it's passive aggressive. The legislature has stated that you need to tax costs against the losing party when a fee waiver applicant wins. This is not me. This is not my voice inventing law out of thin air. This is the legislature's statute that they enacted. We'll talk about that in a second. My application to proceed in form pauperis, and that I would seek reimbursement of the waived filing fee. Next assertion, pursuant to the law, the law requires my ex to reimburse the court. Yes, this is true. If you guys want to see Nevada Revised Statute 12.015 subsection 4, that's exactly what it says. This statute mandates that this $250 is given to the government. So this judge doesn't just screw me over, he screws the government over. He just doesn't care. He doesn't follow any statutes. And this is the first time it's going to come home to roost for him. In any event, I'm seeking my reimbursement of $36.54 for copies and $11.02 for postage, as well as the government's $250, which they are entitled to under the law. I'm arguing that pursuant to the law, my ex has to be ordered to pay the cost that I incurred in bringing forth this special proceeding, which is true. Again, guys, take a look at the statute on your own. You'll see that this is exactly what the judge is supposed to do, and you'll see that this is exactly what the judge refuses to do. Applicable law. Pursuant to Nevada Revised Statute 12.015 subsection 4, well, looks like you don't have to look it up because it's here. If the person prevails in the action, the court shall, not may, shall enter its order requiring the losing party to pay into court within 5 days the costs which would have been incurred by the prevailing party. And those costs must then be paid as provided by law. So this judge here, he knows the law. He cites the law and he ignores the law. So for anyone out there who wants to, think that maybe judges actually just really don't know what's going on and they make mistakes, well, not this judge. This judge was given strict statutory language mandating that a certain thing be done, and he refused to do it. So continue to watch as this case goes on, because I want you to see that there are judges that do this. Next assertion. There is no case law in Nevada defining losing party. That's not true. A party is considered a prevailing party if it succeeds on any significant issue in litigation. This is true. Generally, a party to an action is a person who is designated on the record as a plaintiff, defendant, petitioner, or respondent. Now, this is not true. What he's doing is conflating case law, but that doesn't matter. We'll let the Supreme Court straighten it out for us. Merely naming an individual in a caption in a case does not infer that the named individual is a party to the case. What? Okay, that's not true either. Okay, we'll go ahead and continue on. The Supreme Court is going to be the one setting him straight, so I'm not going to really spend as much time on this because the Supreme Court does it for me. The parties to a cause of action determined by reviewing the entire record of the proceeding. This includes all allegations contained in the petition process, blah, blah, blah. A person does not become a party subject to liability merely by receiving notice of the action. The pleading that provides notice must seek relief against that person, which is what I'm doing. So I'm going to use his own words against him. So this judge here is saying The pleading that provides notice must seek relief against the person. That's exactly what I was doing. If you look at my petition for writ of mandamus, it seeks relief against my ex. So he's going to try to invent his own definition of what this means, but his opinion of what this means will not trump the opinion of the Supreme Court. Their opinion will control. Going into the next section here, because Nevada is a notice pleading jurisdiction, our courts liberally construe pleadings to place into issues matters which are fairly noticed to the adverse party, which is what I did with my petition. Additionally, not all parties are opposing parties liable for costs and fees. This is true. And what he's going to try to do is he's going to try to say that my ex doesn't count as an opposing party, which the Supreme Court vehemently denies. So we're going to go ahead and move on. I'm glazing over a lot of this because the Supreme Court order is actually what's really going to be interesting to you guys, I think. Less my commentary, more the Supreme Court's order. A writ of mandamus is a process by which to compel the performance of an act which the law especially enjoins as a duty resulting from office, trust, or station, or to compel the admission of a party to the use and enjoyment of a right or office. This is something that I've already discussed a number of times when I went over my filings of these writ petitions. I've already filed 2 writ petitions, but as you guys know, you can use a writ of mandamus to force the government to perform an act which is required. Next assertion here, the Nevada Supreme Court has awarded costs against respondents in mandamus proceedings regardless of their official status. So he is recognizing here that the Supreme Court of Nevada does allow you to seek costs against a government agency. I'm going into, let's see what he's talking about here. Okay, regarding costs, the law states that costs must be allowed, of course, to the prevailing party against any adverse party to whom judgment is rendered. Next assertion here, justifying documentation for each individual item of costs must be provided in support of a memorandum of costs. Okay, so he's half right about this paragraph here. It is true that you have to provide justifying documentation for individual items, but only if your opponent opposes the memorandum of costs. My ex did not file an opposition, and my ex did not file a motion to retax costs. So by her not doing that, this portion of the process does not come into play. So the judge is trying to basically defend her for her on his, he's basically trying to act as my ex's attorney by doing this, by trying to pull this analysis into this case. The Supreme Court of Nevada is going to state that in their Supreme Court order. They're going to make clear that what he is doing here is inappropriate. Going into the next section. Analysis. I initiated this suit by filing a petition for judicial review. That's true. Against the petitioner, which is the government, and did not involve my ex in the initial case. The Nevada Supreme Court directed me to include her in the action as a real party in interest, which is good. In the proceeding, my ex was served with the petition for writ of mandamus, which is good. Here, an award of costs and fees is mandatory. Okay, so it's nice that he's acknowledging this, because the second judge is the one that actually plays around with this, and she gets dinged on appeal too. So this judge is not fighting the fact that this is a mandatory award, whereas the other judge will, and we'll deal with her when I file an appeal against her. But for now, we're going to focus on this judge. I'm arguing that the court should not award costs against the government because the proceeding was not filed due to any wrongdoing that they committed. Again, I don't know what these quotes are about here. I'm electing to forego seeking costs against the government in my petition. I'm expressly waiving my right to seek an award of costs against the government, which is true. And I want to go ahead and provide a footnote here, guys. Even if I did not waive my right to seek an award of costs against the government, I strongly believe that I would not have been entitled to an award of costs against them anyway, because they didn't oppose me. They didn't oppose the petition. So they're not really an opposing party because they don't care. So even if I didn't waive my right, I haven't lost anything there because I highly doubt that I would have been entitled to an award of costs against them. I'm arguing that the cost should be awarded against my ex, because she deliberately dragged the proceeding out and because she knew that she was not a victim of DV and she had no intention to renew the fictitious address. She did not appear in the proceeding and her involvement was based upon her obtaining a fictitious address from the government. The Supreme Court ruled that the issuance of the fictitious address was proper. The petitioner also concedes that the respondent properly issued the fictitious address. Therefore, her enrollment in the program does not establish that she committed any wrongdoing. She obtained a valid temporary restraining order. Okay, so this is nice that he has this opinion, but he's wrong. So he's stating that all of these things are in support of my ex not being a bad person, I guess, that she's not evil. Again, somebody in my previous video characterized this judge as seeing me as the evil person and her as the victim who needed his protection. Basically, that he's white knighting for her. This analysis here sounds plausible to the average person, but the Supreme Court of Nevada is going to reject it and overturn his decision. My allegation that my ex unreasonably and deliberately dragged the proceeding out is belied by my acknowledgement that her previous litigation in the matter. So again, he's trying to use my own words against me, but this is not something that's going to amuse the Supreme Court. Just because you've taken a snippet of my language out of my motion and you're going to say, well, I don't agree with this particular snippet, it doesn't mean that you're going to be able to get the law to work in the favor that you want it to work. So he's trying to say that that he doesn't agree that she deliberately dragged the proceeding out. And because he doesn't agree with me, therefore I'm not entitled to an award of costs. But that's not how the law works, and he should know better. Going into the next section here. I was also arguing that my ex forced me to incur additional costs because she wasn't willing to settle the case. That's true. I'm stating in my petition that mediation is futile because me and my ex involved in a bitter conflict. Okay, so again, he's trying to twist my words into something that I'm not saying. He's trying to use the fact that I said mediation was futile against me. He's basically acting like a win-at-all-costs attorney, which is strange. Because he's not the attorney in this case, he's the judge. He shouldn't be doing this. In any event, he's trying to say that because I said mediation was futile, that it is my fault that she couldn't settle the case. But this is a ridiculous notion because you don't have to go to mediation to settle a case. You can file an answer that admits all the allegations. You can send an email that says, hey, I want to stipulate to this being, closed. There's a whole lot of ways that you can actually try and stipulate the case. You don't have to go to mediation. So what he is doing is something that I explained in the video, They Will Never Say Good Things, where he is taking one little thing and he's plucking it out because that's all he has. And he's using that argument, even though it's absurd, to try to justify that he plausibly came to a reasonable conclusion in this case as to why it should be denied for costs. Again, the Supreme Court of Nevada is going to reject this. Going into the next assertion here, I'm stating that in my motion I will not appeal an order in relation to my ex's request. What? This isn't true. This isn't true at all. So I remember the Supreme Court taking this exact language out of this judge's order, and they're going to lambaste him over it. So they're going to say something like, the judge says that Alex waived his right to appeal. We reviewed the record. No, he didn't. So they're going to call him out on this as a liar. Well, they're not going to say that he's a liar, but they're going to say that he says this one thing and they reviewed the record and it's not true. So I guess you can sort of infer what you want from that. Next assertion here is that I cannot assign... This is laughable. He's trying to say that I cannot assign responsibility for costs to one or two parties. What? Yes, I can, and you will be told so by the Supreme Court. Let's move on to the next section. Based on the foregoing reasons, the court is without basis to find that my ex is a losing party pursuant to the law or that the adverse party against whom its judgment is rendered. Additionally, I have waived my right to appeal. So he says it's not true and it's not going to work. I would like to mention one more thing. I have stated this before in the video standard of review. The judge is entitled to deference only on his findings of fact. But there are no findings of fact in this order. This is a pure question of law. This is where the judge is the absolute weakest and most vulnerable to being overturned on appeal. Anytime you take to the Supreme Court pure questions of law, the judge is entitled to no deference whatsoever. The Supreme Court of Nevada will apply their own understanding and their own opinion, and they will supplant the judge's reasoning with their own. So he is completely vulnerable to appeal on this. He's made a huge mistake with this order. So he's basically asking to be reversed, and he will get reversed. Next assertion here is that the court notes that the amount of costs sought by me is not large. However, neither my claim for postage nor copies is supported by receipt for payments in the amount claimed. So this last sentence here is another portion of the abuse of discretion that I mentioned earlier in this order. He can only go into these details if my ex files a motion to retax and if my ex files an opposition. She has done neither. So he can't do this, and the Supreme Court of Nevada will explain this to him. For these reasons, his request for costs is hereby denied. So this last sentence here is what will be overturned. It is hereby ordered. Next assertion here is a certificate of mailing, Rule 5B, certifying that he mailed this document to both myself and my ex, and that he certified that he electronically served the government with this order. Boom! Notice of appeal. So I hit him with the notice of appeal, and I think it's a same-day notice. Let me see here. Really quick, let me check. No, it's not. So I took some time to research this. So I filed a notice of appeal, and I'm indicating to this judge that his order denying requests for costs will be appealed to the Supreme Court of Nevada. Rule 5 Certificate of Service, indicating that I have mailed this document to both my ex and the government. Next document, Case Appeal Statement. I've gone over these before a number of times. Because I am representing myself and I don't have an attorney, the rules of appellate procedure require the district court clerk to prepare the case appeal statement for me. So the district court clerk went ahead and prepared this case appeal statement. I've gone over these a number of times in the past when I filed appeals. I really think that it's one of those things that you guys aren't going to need me to go over again and again. It's very specific what needs to go into the case appeal statement. It's typically things like who is appealing, who is a respondent, who had a lawyer, who didn't have a lawyer, was a fee waiver granted, what's the order that's being appealed, which judge entered the order, all of these little details. It's very formulaic what goes into this document, so I'm not going to spend any time on it. Go ahead and review it, and if you guys have any questions, just go down into the description below, click on the link, download document for yourself, and if you have any questions, go ahead and post them down into the comments below. Order of recusal. The judge is gone. What's crazy about this is I didn't even ask to get rid of him. He just got rid of himself. This judge is going to recuse himself from this case and be replaced by a new judge because he does not like my website. The website is called Our Nevada Judges. I encourage all of you to take a very close look at that website. This website has triggered an order of recusal in this case because he claims that because of the website, he can no longer trust me as an honest person. Let's go ahead and go into this order of recusal. A judge in Nevada has a duty to sit. In other words, in the absence of some statute, rule, or of court, or ethical standard, or some other compelling reason to the contrary, the trial judge has a duty to preside to the conclusion of all proceedings. Pursuant to the Code of Judicial Conduct, a judge shall disqualify himself from any proceeding in which his impartiality might reasonably be questioned, including if the judge has a personal bias or prejudice concerning me. The commentary to Canon 2 states that the test for the appearance of impropriety is, quote, whether the conduct would create in reasonable minds a perception that the judge's ability to carry out judicial responsibilities with integrity, impartiality, and competence is impaired, unquote. In considering whether a judge's impartiality might reasonably be questioned, the Supreme Court has described the test as, quote, whether a reasonable person, knowing all the facts, would harbor reasonable doubts as to the judge's impartiality, unquote. The Nevada Code of Judicial Conduct, Canon 3E1, provides that, quote, a judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, unquote. Petitioner, Mr. Falcone, was involved in an opponent's campaign against the judge for Department 11. This fact by itself does not necessitate recusal. He cites some cases here that discuss that. However, in addition, I have created a website which contains what he says is false information about the undersigned judge's record. So what he is complaining about is that I am reporting all of the decisions that have been overturned on appeal. The website asserts that false information is truthful and urges voters to consider this information in the upcoming election. He does not like that I am telling the voters that he has screwed up a few times and been overturned on appeal. In accordance with Commentary 9 to the Nevada Court of Judicial Conduct, Canon 4, Rule 4, Subsection 1, campaign staff for the undersigned judge responded directly to me and informed me that my website contained false information and demanded correction or removal of the false information. I refuse to correct or remove the false information, so he says. We're going to go over these emails that I received from his political operatives and specifically what I asked them to do. These political operatives claimed that this judge did not make the errors, and I asked them for some kind of documentation to support which judge did make the errors, because at the time, these cases were either not indicating the judge that was overturned. There was something specific that was wrong with those cases. I'm not going to talk about it now because I filed an affidavit and those emails get included, and that's going to be the best time to talk about it. So hang in there. When my affidavit gets filed and I attach the emails, we're going to go over the details as to what he's talking about here. My refusal to correct or remove false information from the website concerning his record informs his belief as to my credibility. Mandatory disqualification is required if impartiality might reasonably be challenged. Accordingly, the undersigned recuses himself from the case. So what I think that this judge was doing is I think he was trying to find a reason to get off the case. I don't think he wanted to sit on this case anymore. I think he was in on over his head. He didn't know how to handle this case. He didn't understand high conflict child custody. I think that deep down, there was severe signs of bias in this case by this judge. And what he did was he took the website and he weaponized it to basically justify his ability to get off the case. In other words, he was wanting to get off the case anyway. And he just found the first reason that he possibly could to get off the case. When we go over the emails, you'll be able to see that because all he had to do was respond to the email, but he didn't respond to it. He just took my email and ignored it, and then he used that as a reason to get off of this case. Again, guys, Our Nevada Judges is impacting the judiciary in this state. This is a real world impact where it caused my judge to recuse himself. It's not deniable anymore that the judges are very much concerned about the way that they appear on that website. Let's go ahead and scroll down. Certificate of mailing. He mails the order of recusal to both myself and my ex, as well as the government's lawyer. Next, we have the case assignment notification. So this case assignment notification is indicating that this matter is going to be moved from Department 11, which is Judge Chuck Weller, to Department 13, which is Judge Bridget Robb. Certificate of service indicating that this document was submitted electronically to both District Judge Bridget Robb. She no longer has the last name Robb Peck. She divorced him, so it's just Bridget Robb now. And this attorney, Kevin Benson, which is the government's lawyer. And this document was mailed to both myself and my ex. Next assertion we have is an order directing transmission of the record. This order was entered by the Supreme Court of Nevada. They are on to this judge. They are stating that they have reviewed the documents filed in proper person on appeal, and they have concluded that their review of the complete record is warranted. Within 30 days from the date of the order, the clerk of the district court shall transmit to the court of the Supreme Court, to the clerk of the Supreme Court, the entire record in this case so that they can review this judge's order denying motion for costs. This is done by Chief Justice Gibbons. Next assertion here is the district court's certificate of clerk and transmittal. The district court clerk is indicating that they have received the order from Chief Justice Mark Gibbons, and they are complying with the Supreme Court's order, and they are transmitting the entire record to the Supreme Court immediately. Next assertion here, or next document here, is a notice of change of address filed by myself into this case, indicating to this court that I have moved. Again, guys, this is an old address, so I don't really care that you guys have these details. Rule 5, certificate of service at the bottom, indicating that I mailed this document to both my ex and the government's lawyer. The district judge has disposed of my motion for costs. He has done so by denying that motion, and of course, that's not going to last long, guys. Going into the aftermath, I have filed, it looks like two documents. And those two documents were supposed to cost me quite a bit of money, $250 in costs and $500 in an appeal bond. But because I got a fee waiver by Chief Judge David Hardy, I didn't have to pay those costs. So I incurred $0 in costs. My ex's attorney did not participate, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney fees were also at $0 because she did not participate in this case. The government's lawyer would have he would have had to have reviewed these documents, as frustrating as it is for him, because I'm not really trying to seek any kind of award of costs against him. He still has to at least read the documents. So I think under the circumstances, it would be reasonable to say that he would, and that order of recusal would have especially been important for him to read. I was going to say 15 minutes for all of these documents, but instead I'm going to say 30 minutes for the government's lawyer to review these documents. By the way, he didn't file anything, so he would have incurred $0 in costs, but he would have incurred half an hour in attorney fees, which at the rate of $250 an hour, we're going to put down as $125 in attorney fees for the government. As with my previous videos, I will go ahead and let you guys have that opportunity to post any questions you have down in the comments below, and I will see you guys next time.